Landmark judgment coming in from the Supreme Court. Now, the Supreme Court has ruled Section 66A of the Information Technology Act as unconstitutional. The bench of Justice Chelameswar and R.F. Nariman have now pronounced that Section 66A will be struck down. That is the latest that is coming in right now. As we break that information to you, Supreme Court has struck down Section 66A of the Information Technology Act. The Supreme Court pronouncing its verdict on the batch of petitions challenging the constitutional validity of these section of the cyber law. Meenakshi is also with us for more on this. And Meenakshi, you were giving us the details of the observation that the court made on this particular Section 66A, also saying that just an assurance from the government is certainly not enough.
Yes, absolutely. That was one of the reasoning which the two-judge bench has given in its order as it has gone ahead and struck down the constitutional validity of this particular section. Of course, the details order will emerge shortly because, again, the pronouncement is still underway as it is going to be a longish pronouncement, which was, Justice Rohinton Nariman, Honorable Justice Rohinton Nariman, at the outset clarified that it is going to be a longish pronouncement from a person who otherwise occupies little space. That was a little touch of humor that he inserted as soon as he came inside to pronounce the judgment. So as we are speaking, the pronouncement is still underway, but we are bringing to you the primary and the basic reasoning of the court as it has arrived at its decision, and that is three, essentially. One, that this section is it's invaluable insofar as the freedom of thought and expression is concerned, which, according to the Supreme Court, is the cardinal rule in democracy. Secondly, this section does not come in the way of disrupting public order, as was argued by the government before the Supreme Court. And thirdly, the Supreme Court is of the point of view that any assurance by the government, as we saw in the case of this particular section, when the Solicitor General was present in the Supreme Court and he was arguing as to how perhaps the Supreme Court should not strike this section down entirely, but give some directions to the government to bring in detailed guidelines or regulations as to what constitutes objectionable or not. But the Supreme Court clearly telling the government, as it is still pronouncing its judgment as we speak, that clear assurance on the part of the government is not sufficient, that this section will not be misused at any point in time in the future. So clearly,